I'm not sure if everybody's heard of Parent Network of Western New York. We are a nonprofit organization, and our mission is to support families and professionals to empower individuals with disabilities to reach their full potential. So how does that look different maybe than another organization? So what we really focus on is helping families through the lifespan. So 0 through adulthood. And our goal is to help support families, to educate the community, to connect people with us and with each other, and to empower others. So how do we accomplish that mission? Support, we help people understand the disability that they may have or that a family member may have. We try to help them obtain early identification and intervention services, access healthcare, social, vocational, and educational services. We work to educate. That means we provide workshops and trainings within the community to parents and professionals on many topics to support individuals with disabilities. So think of this, we might go into a school and do some education with professionals on different sort of topics. We might work with teachers, we might work with the staff at agencies. We offer a lot of different types of workshops and trainings and professional developments. We connect, so our job is not just to connect families with services and providers, but also with one another. So we run support groups at our agency that help families connect that have disabilities, and that is a really great service that is offered. And our main goal is to empower people. So we provide resources and help parents develop knowledge, confidence, and skills to get the services they need and to support their child's development through the lifespan. And basically what that means is eventually our hope is that you may not need us. So we're going to give you tools, we're going to give you help and support so that you can move through being able to empower yourself and your family and eventually your child as well. We have family support services specifically through OPWDD. Those are services that families do need to qualify for through that service through New York State. And that is our Medicaid eligibility navigation, our OPWDD eligibility navigation service and our family behavioral support service. And those are things that if you're interested in them, you can contact our agency and see if it's something that you would be eligible for. We also have family support and advocacy, where we provide family support specialists to individuals and families to be able to help them navigate these really complicated systems that are for our folks and kids with disabilities. And when I say disabilities, I mean all disabilities. So that's visible and invisible disabilities, ranging in everything from mental health disabilities to kiddos with autism and everything in between. So if you or someone that you're working with or yourself think that you might be able to utilize our services, please feel free to reach out to us. Everyone that works in our office is not only a professional advocate, but we all have family members or our parents of individuals with disabilities in the range of what that means. So please know that we are here for you as professionals if need be, as if you are parents, we're here for you, and please let us know what we can do to help. And now I'm going to stop sharing and I'm going to turn it over to Hannah. Hannah, please feel free to share, and I'm going to mute myself.
Thank you, Emily. Thank you so much. And thank you to Parent Network for giving me this opportunity to share information about our program and also about the rights that folks have when they're faced with the CPS investigation. Emily, you've been a great support and a great cheerleader for getting this information out, which I think is so important for the community. So love Parent Network, love Emily. So thank you so much for being a great collaborator with us. So I'm Hannah Holden. I am a family court social worker with the Assigned Counsel program. And this is our information. I'm pretty sure Emily's going to share this information with you guys. Either she already has or she's going to after this presentation. So what we're going to talk about today, we're going to talk about what the assigned counsel program is. We're going to talk about what CPS is, how CPS investigates reports of maltreatment, what an unfounded versus an indicated report means, the difference between abuse and neglect, what the standard is to remove a child, because sometimes people, that's our main worry, right? Like, oh my gosh, what's going to happen? What the current situation is in the landscape as far as legal advice related to a CPS investigation. What are our actual individual rights during a CPS investigation? And then I'm going to tell you a little bit about this pre-petition attorney on call or pre-petition legal advice program that we're now offering at the assigned counsel program in Erie County. So the assigned counsel program, our mission statement is so great that I always like to flash it on the screen because I joke that it makes me want to stand up and salute. It's sometimes not-for-profits have mission statements and you can't really tell what they do, but I think ours is very distinctive and impressive. So the assigned counsel program, it's a not-for-profit legal agency. And the program strives to help those who cannot help themselves, who face steep odds against the power of the state, who struggle with poverty, mental issues, helplessness, and dread. And the attorneys in the program save lives and save families. Now, tell me that is not an amazing mission statement, right? Like they're pretty awesome folks, and they do work with people facing both criminal court cases and family court cases. And they are the folks that are assigned to represent individuals who are low income or impoverished, who can't afford an attorney for themselves. Frankly, with the rates that attorneys charge, I think that's pretty much all of us. Normal folks can't afford like a $2,500 retainer just to get advice over the phone about a basic case. So the assigned counsel program is here for us. The other piece that we need to kind of define our terms is what is Child Protective Services. So Child Protective Services is part of our local Department of Social Services, and they are the people who go out and investigate allegations of abuse and neglect. So you know, if one of us believes that a parent or a caregiver is abusing or neglecting a child, we call the statewide central register of child abuse and neglect. If they hear an allegation and if it was true, it would rise to the level of abuse or neglect, then the statewide central register will send that report to the Erie County Department of Social Services. And they will then, the Erie County Department of Social Services will begin an investigation. So a CPS investigation requires that within 24 hours of that state central registry report, Erie County must begin an investigation. Within 24 hours, they have to lay eyes on that child. So there's an after hours staff that works just to make sure that on the weekends, one of the CPS workers will lay eyes on the child. And then within 60 days, an entire investigation has to be done, including home visits, face-to-face interviews with the subjects of the report, the family members of the subjects, including all of the children that live in that household, and any other children of the parents or caregivers that are named in the report. They also get information from any other collateral contacts that may interact with that family, any service providers, the children's school, if the family is engaged in any kind of supports like mental health services, they will speak to all of those providers. They will review reports from, like I said, healthcare providers, law enforcement, if there's been any kind of law enforcement involvement with that family, and they will also pull any previous reports to the state central registry about that family. And then within that 60 days, they'll make a determination. So the determination will determine if this report is indicated, meaning that there was a fair preponderance of the evidence, that's the legal standard, a fair preponderance of the evidence that the allegation is indicated to be true. Or there's a fair preponderance of the evidence that is unfounded. So the allegation is probably not true. If there's a fair preponderance of the evidence that the allegation is true, the report is called indicated. And if it's not, then the report is unfounded and sealed. Now, an unfounded report is maintained at the state central registry, but it's sealed. So by sealed, that means it's only available to police or the local Department of Social Services, or really any Department of Social Services, if there's another report, like a subsequent report about the same child or the same parent or caregiver. And then the police, like law enforcement, so it could be the sheriffs or the state troopers, law enforcement or a Department of Social Services can see the sealed report. And the reason that they're able to see it is if there's a pattern. So even though the investigation did not, based on a fair preponderance of evidence, it did not show that it was likely that it really happened. But if there's a series of these unfounded reports, then they start to look a little bit more carefully. And it's like, is there something that we missed? But a sealed report is not available to employers or licensing agencies or anything like that. An indicator report is where things get obviously very serious, right? So an indicator report of abuse is kept at the state central registry until the youngest child named in the report is 28 years old. I'm going to say that again. An indicator report of abuse is kept at the SCR until the youngest child named in the report is 28 years old. Now, indicator reports of neglect used to be kept for that long, but just last January, the state assembly and the state Senate, they changed it. So indicated reports of neglect are now maintained for 8 years, and then they're sealed. But an indicated report of abuse or neglect is available to child care employers. It's available to foster and adoptive agencies. It can affect an individual's ability to obtain employment in child care, to become a foster parent, to adopt. It's available, and it can affect individuals' ability to work with any kind of a vulnerable individual. And I'll just give you an example. So say that you are a parent like myself. So I had a 16-year-old in the home. I had at the same time a 4-year-old and a 2-year-old in the home. And let's say I'm struggling parenting with my 16-year-old and a report is called in on our family. And let's say it's indicated. That report is going to be kept at the SCR until my 2-year-old is 28. So it's going to bar me from a lot of really viable employment options for a really long time. It's going to keep my family from being able to access those employment options, because it's not just going to be me, it's going to be my partner as well as another parent or caregiver in the home. So what is considered abuse in New York State? Abuse in New York State is when a parent or other person legally responsible for the care of a child, so it could be a boyfriend, girlfriend, partner, or even a child care worker, inflicts upon the child serious physical injury, creates a substantial risk of serious physical injury, or commits an act of sex abuse against the child. Pretty straightforward. So what is considered neglect in New York State? Here things get a little dicey. When a parent or person legally responsible for the care of a child harms a child, places a child in imminent danger of harm by failing to exercise the minimum degree of care in providing the child with any of the following: food, clothing, shelter, education, or medical care, when financially able to do so, right? When financially able to do so. I like to repeat that last phrase because sometimes it's hard to piece out what is neglect and what is poverty. And poverty itself is not a reason to indicate a report. It's not a reason to find a parent or caregiver guilty of neglect. But it can be difficult to figure out what is the cause of the reason that the parents are not providing shelter. Are they homeless because of neglect, or are they homeless because they're impoverished? Same thing with food insecurity. And as you know, as a former employee of the Department of Social Services, I was never a CPS worker, but I worked with that department. And I want to give absolute credit to the folks who do this job. And I don't want anything that I'm saying this evening to be taken as any kind of criticism of my former colleagues who do this very difficult job, because it is a very difficult job. And that is, proven by the fact that there's between 35 and 50% turnover every year in the people who do this job. So you've got a lot of really stressed out folks doing a very difficult, very important job, and they're all kind of learning. And you've got team leaders who are supervising teams that are turning over quite a bit. And you've got people coming in, the job requirement is a bachelor's degree, but not a bachelor's degree in social work, just a bachelor's degree. So I could come in with a degree in business, a degree in political science, and it takes a year to pass probation to do this very difficult, stressful, important job. And yet my colleagues, I look to my left, look to my right, they're changing and churning all the time. And my team leader is having to manage a team that's churning and also educate me about how to make that delicate determination of whether a parent is housing insecure because they're neglectful or because they're poor. I just want to be really clear that if they miscall that and indicate a report on a poor family, rather than there wasn't really neglect, I can understand why that happens sometimes. It's not right and it's not okay, but they're working under really stressful and difficult conditions, trying to do this busy, stressful, important job. And on top of it, they probably don't get paid enough. So I'm just saying I understand sometimes why things can go pear-shaped in that situation. So we talked about what the long-term implications are of an indicative report for a family. Neglect is 8 years, abuse, 28 years after the youngest child, 28 years. So that's, when the child is 28 years old, the youngest child. So that's a really long time. And if you think about anything that was related to poverty, so let's say abuse happened as a result of the stressors in the house because of poverty, and the parent now can't seek employment in these industries that would have been available to the parent because they now have an indicative report, it can be a perpetual cycle for a family. And another way that it affects families is, you've heard me say, that they cannot then provide care to a family member who might need care because they've come into the system themselves. So let's say, I'm the person with the indicative report and my sister's children come into foster care. I can't be a resource to care for my nieces because I have an indicator report, even though maybe I've, taken classes and I've tried to improve, my own parenting skills, and I've recognized my deficits and I want to move forward. I can't do it. So my nieces would then go into stranger foster care because there wouldn't be a family resource for them. So there's some generational effects that can come from these things. I just wanted to go over what the standard is to remove a child, because I think that's all our worst nightmare, right? When we get a phone call or a CPS knocks on our door, we always imagine that they're going to take our children. And honestly, when a child is old enough to know that CPS is investigating their family, that's their worst fear too. Because they know, I'm putting that in air quotes, they know what CPS does. CPS takes children. Obviously, that's not what CPS does, but that's, in the public consciousness, that's what we think that CPS does. It's not. CPS does investigations. And if they recommend that a child be removed, that goes to family court, and family court judges make that determination. It's not a determination that the CPS worker makes. But the standard to remove a child is evidence and information gathered during the investigation determines that the current situation presents an imminent danger to the child's life or health. Imminent means right now. So if it's something that's been going on for 3 or 4 days and the child's still okay, that wasn't an imminent danger. The children didn't need to be removed. So if it's something you were concerned about on Thursday and on Monday they're still okay, that wasn't an imminent danger and they don't need to be removed. But CPS does need to make the case in front of a family court judge. They request a remand, and the family court judge, on the basis of the information provided to them, will will order the removal, or they might order other types of interventions to ensure the safety of the children. So they might order that intensive preventive services are put in place just to make sure the kids are okay. But during this investigative period, during this 60 days, I just really want to reinforce how invasive a process this is. So, CPS is talking to basically anyone who knows this family and everyone who knows this family, because they're trying to figure out if the kids are safe. So they're talking to your neighbors, they're talking to the kids' teachers, they're talking to your pediatrician, they're talking to your physician, they're talking to your counselor. They are talking to everyone and anyone they can to figure out if the kids are safe. So like I said, first of all, it can be enormously scary because you're worried about what's going to happen with your family. It can be enormously embarrassing to have everyone in your orbit know that this accusation has been made. Because let's be honest, we're all, all of us are subject to being concerned and embarrassed that people would think something like this was true of us. And for the children, like I said before, if you have a child who's old enough to recognize that this kind of investigation is happening to their family, it's enormously traumatic for them because they are in the middle of this uncertainty during the investigation as well, and they don't know what's going to happen. So it's just traumatic for the entire family. It can actually, in your children's mind, it can actually call into question the parenting ability and even the authority of their parents, because the state, writ large, is coming in and is investigating their parents' ability to parent their family. So there's a lot of repercussions just of the investigation itself. So right now in Erie County, there's a lot of volunteer legal organizations. So there's the Volunteer Lawyers Project, there's Legal Aid Bureau, Neighborhood Legal Services, and our organization, which is the Assigned Counsel Program. But up until now, none of these organizations have provided pre-petition legal advice to low-income and poor folks during the period of the CPS investigation. We have been available to parents when a CPS investigation has gone to the family court stage. So a judge has either ordered that the children do need to be removed from their parents' custody, or they have mandated services. So I said maybe the judge won't require removal, but they might put in intensive services. When it gets to that stage, people do have access to free attorneys. But prior to that stage, there has not been free legal advice available to people. There is no requirement in law in New York State that the CPS workers advise clients of their rights. So in a criminal situation, the police have to give us the Miranda statement, right? You have the right to remain silent. If you can't afford an attorney, one will be provided for you. There's no equivalent on the CPS side. So the workers don't have to tell us what rights we have. And then even if an individual who's under CPS investigation knows what their rights are and wants to assert those rights, very often, and this is unfortunate in our society, but very often, if you don't have an attorney to protect those rights for you in court, you really don't have those rights. And I think of, the equivalent kind of on the housing side would be, yes, your landlord can't evict you without a certain process. They have to give you a notice and they have to nail it on your door and they have to do this and that in 10 days and whatever. But that doesn't stop them from just coming into your apartment and putting your stuff out on the lawn unless you have an attorney to protect your rights in housing court. Same thing with the CPS process. If you don't have legal advice and legal, representation, it's hard to really get those rights really protected. And then finally, given the correlation of poverty with CPS involvement, which is a very high correlation, 80% of people who have a life event like poverty, like homelessness, are investigated by CPS, 80% of them. So given the correlation of poverty with CPS involvement, even knowing you have the rights might not protect your interests because you can't afford a lawyer, can't afford the attorney. Like I said, $2,500 as a retainer is not something that's easy for any of us to come up with, I don't think. So given all of that, what are my rights? Let's go over what those are. What are my rights during a CPS investigation? Finally, I've talked for 20 minutes and finally I'm getting to the meat of the matter, right? Our rights during a CPS investigation are to know the details of the allegation that was made against us. So we do not have the right to know who made the allegation. That's anonymous. And that's just, right now, calls to the SCR are anonymous. But we do have the right to know the specific allegation. So it's not just, hi, Hannah, someone made a call to the SCR and accused you of abuse or accused you of neglect. No, they actually are required to read you the allegation. They can't be vague. They have to read it to you. You have a right to speak with an attorney before speaking with CPS. So knock, knock, knock. Hi, I'm from CPS. There's been an allegation. This is what it is. I'd like to come in and speak with you about it. Actually, I'd prefer to call my attorney and speak with them about what I'm accused of, and then I'll give you a call back and let you know when a good time to talk with me is. You have the right to do that. Many CPS workers don't let the folks under investigation know that because it's not convenient for them. But anybody who's under CPS investigation does have the right to speak with an attorney before speaking with the worker.
Hannah, can I just interject too? I'm really
Please.
sorry, but I wanted to reiterate something that you mentioned when we were meeting before, because I think it's really important at this point to remind people that if children are in imminent danger, they would have already had a court order to be removed. It's not like they're going into a home where children are being immediately impacted by very harmful situations.
Yes.
This is just to talk to the family and people about what is being allegation.
Exactly right. Yeah, no, Emily, and I'm glad you said that. So if children are, they're being abused and they're being abused in that moment, and there is imminent, like right in that moment, abuse happening. First of all, you're not calling the SCR, you're calling 911. Let's be honest, right? If a child is bleeding, if a child is, not breathing, if a child is being harmed to that extent, you're calling 911. You're not calling the state central register and hoping within 24 hours that someone from the county comes out and speaks with the family, right? You're calling 911. Secondly, if CPS believes that abuse at that level is happening, then, and if they have to be pretty darn sure, but if they do, they might do what's called an emergency removal. And these are very few and far between. But if they believe that children are being harmed to that level, they will do an emergency removal and they will come and they will take the child or children and then immediately go to court as soon as it opens the next day and speak with the judge and say, Judge, this is what we did. We believe this to be true. And on the basis of this belief, we removed this child from their home on an emergency basis. And Judge, do you think we did the right thing? And sometimes the judge will say, absolutely, yes, I would have granted that remand if you'd come to me first, or no, you guys screwed up and you need to return the kid. It sometimes goes one way, it sometimes goes the other. It's all emergency removals are not like rubber stamped. It really does hang in the balance. But those are the two, like when a child is being seriously harmed, it's either a 911 or it's an emergency removal. So
Hannah,
yeah.
do you prefer questions? Do we want to save questions till the end? There were just a couple of great questions in the chat, but we can save them till the end if that's easier.
We are like two slides from the end, and then it'll be open season for questions, I promise.
Okay. Awesome.
So, yeah, let me just get through these rights, and then we're almost to questions. So you have the right to refuse CPS entrance to your home without a court order. So here we go back to, if the CPS worker is that concerned about your children, they will immediately go to court, get the court order from the judge, and they'll be back with that. And you have to let them in. You have the right to keep your immigration status private. So if you are a new American, if you are here on refugee, asylee status, if you are a permanent resident, it does not matter at all. You can't be asked. It doesn't affect your investigation at all. You have the right to have an interpreter if you need one. So your brother-in-law should not be the one coming over to your apartment and interpreting for you and the CPS worker. There needs to be an independent individual who is there interpreting for you and the CPS worker and anybody else who comes as a part of this process. So if English is not your first language, you really need to understand what's happening. It's very important, and it needs to be an independent individual. Definitely not your kids. Never your kids. You have the right to refuse mental health or drug evaluation without a court order. So many times people go ahead and submit to a drug test and implicate themselves You don't have to do that without a court order. You have the right to refuse to let CPS question your children without a court order. Now, very often, CPS will just show up at your kid's school and they'll talk to your kids before you even know what's happening. So you can prevent that by putting something on their permanent record card that says, just in case CPS ever show up, please call me first and let me know what's happening. Because frankly, do you want your kids, and how would your kids feel if some complete stranger comes in, takes them to a room and says, hey, I want to talk to you about what happens in your home? How would your kids feel if they hadn't talked to you, if they didn't know what that was happening? My kids would be a little freaked out, and they're teenagers now. So, and you have a right to refuse services recommended by CPS. However, whether you should exercise these rights or not is something you should discuss with a legal advisor, right? It's kind of like on TV shows, whether you should plead the fifth or not is something you do on advice of your attorney. You don't just decide willy-nilly whether you're going to testify on your own behalf, right? You talk to your attorney and you follow their advice. And it's always the people who testify on their behalf that mess things up, right? But I'm just saying, you want to have somebody who knows your situation, who tells you, do you let the CPS worker come in or do you not? Do you let them talk to the kids or do you not? Do you take that drug test or do you not? So what do we do with that? Well, we now have at the Assigned Counsel program, we have a legal advice hotline that should be starting any day now. It's not quite ready, but it's coming any day now. A legal advice hotline where people who are experiencing a CPS investigation can call and talk to an attorney or possibly a paralegal, but a legal advisor who they can talk to about their specific situation. And they can say, hey, you know my situation now. Should I exercise my rights? Which of them should I exercise and which of them should I not? And they can get advice for free from a legal advisor. We also have a full-time family court social worker. So if the family that calls, the attorney believes that they could benefit from some social work support, maybe whatever brought them to the attention of CPS in the first place, could be housing insecurity, food insecurity, mental health issues. If they need some support getting connected with community services, the family court social worker will work with that family during the investigation phase. And our hope is by doing so, we'll have better outcomes for the entire family, including the kids, right? Our focus is on the kids. We're trying to make things better for the kids. And we're going to do an awareness campaign for this phone number once it's up and running. And the other piece of it, obviously, is me just talking to people about their rights and letting everybody know. But like I said, our hope for this entire program is that by having holistic legal intervention, including social work support, in parental representation matters, meaning in folks who are experiencing CPS investigations, we're going to have better outcomes for the families that we serve. I'm going to stop talking and I'm going to stop